When you enter a contest, do you know the rules and does it make a difference? Well, that takes us to this week's case. Involves a real man. Luis Cortés lives in Puerto Rico. Luis entered a contest that was sponsored by Sony and Ricky Martin. And the contest was for an original song. And if the song was selected, there was a possibility that it would be used at the next World Cup for soccer. Well, Luis entered a song. And he sent along not only the lyrics and the music, but he sent along a music video that he put together about the song. Well, within a couple of weeks, Sony approached him and they said, we got this entry, but we need to have you sign a release and also an affidavit indicating that these are the rules and that you understand the rules. Well, he signed everything. He was excited about the fact that he could win this contest, and unfortunately he lost. He lost. Well, a couple of months later, as a matter of fact, only about 4 months later, a song comes out by Ricky Martin that is very, very similar to the song that Luis had submitted in the contest. And he wasn't happy with this, needless to say, and he looked to Sony and he said, you guys, Sony, have stolen my song and I am suing you. And he found an attorney who was willing to take the case, and he brought suit in the U.S. District Court in Puerto Rico. Well, Sony, on their behalf, argued, hey, wait a second, you knew what the rules were. You signed an affidavit where you said you knew what the rules were, and one of the rules is that if a dispute arises out of anything to deal with this contest, that you have to go to arbitration. Well, on his behalf, Luis argued, no. This doesn't apply here because basically what happened is you guys sent me this after I had already submitted the song to you. You already had the material. Then you asked me to sign that I understood the rules. Well, I signed that I understood the rules, but really you coerced me into signing that, or basically I think it was fraud by virtue of the fact that I didn't fully understand what was going on, and therefore that agreement isn't enforceable. That's what he argued through his attorneys. Sony said, give us a break. In this instance, we sent you an affidavit. The affidavit said you understood the rules. You signed that. One of the rules was that if there was any dispute, it goes to arbitration. Okay, well, the case was filed in U.S. District Court, and the judge heard these arguments and said, you know what, Sony, you were right, you are right. There's an arbitration clause provided in this agreement, and in this instance, the case must be arbitrated. Therefore, basically, it's thrown out of court, and it must go to arbitration. Well, Luis wasn't happy with this, and through his attorneys, he appealed this, went up to the First District Court of Appeals, and there it was found at the First Circuit Court of Appeals that the district court was correct. The district court was correct, and that an arbitration was necessary, and therefore Luis did not have a case. His only remedy was going to arbitration. Now, he didn't want to go to arbitration, but that's all the remedy that he had available to him. Now, why don't people like arbitration? They don't like arbitration clauses for a couple of reasons. One is you don't have a right to any jury. Two is that usually there are clauses within the arbitration clause that provides for the guy who wrote the contract. In this case, it would favor Sony. And for these reasons, people generally don't like arbitration clauses, mandatory arbitration clauses in contracts, and like to get out of them. But as you can see, when they are there, and when people who enter those contracts acknowledge that they know there's an arbitration clause there, they're going to be held to those arbitration agreements. So what is the lesson we learn from this? The lesson we learn from this is very simple. When you're entering a contract, find out whether there's an arbitration clause in that contract, because you're probably going to be held to that arbitration clause. If you don't like it, you can cross it out and initial it. If the guys who you are trying to do business with say you can't have a deal unless you have the arbitration clause in there, write them a letter that says, I want to have your service or product, and you're the only guys that are offering it, and I therefore want to have that service or product, but I don't want to sign a contract with an arbitration clause. If they get back to you and say it's got to have an arbitration clause, write them a letter and say, okay, I'll enter the contract, but only if you get rid of the arbitration clause. If you can't get rid of the arbitration clause, I'll sign the contract because you're the only guys that have this service or product. Now, I don't know that that's going to get you a long way, but it will help you. Why? Because if the contract is with a company that is the only company providing that service or product exactly as you want it done, and they refuse to provide that to you without an arbitration clause in the contract, you can always argue that that was an adhesion contract. It was a contract that you were forced to sign, and therefore later you may have a good basis upon which to attack that arbitration clause and not have to go forward with it. Okay, we bring you this case, we bring you cases every week so you understand how the law works. I'm David Allen.